Hello, everyone, and welcome to Carolina Breast Friends YouTube channel. Today, we are talking with Holly Simpson about estate planning. She is with Simpson Law Firm, and we're so thrilled today to have her and excited to learn about the next steps for estate planning and answer some of our questions. Thanks for being here, Holly.
Yeah, thank you for having me. This is super fun and a topic I'm passionate about. So thank you. You want me to, am I good to start going?
Yeah, go ahead and do your screen share.
My screen.
What? No, muted. You want to say hi?
All right, everybody see me okay? Or see my screen, I should say.
Yes.
Okay. Yeah, thanks for the introduction. So yeah, my name is Holly Simpson, and a little bit about me. So I'm a state lawyer, of course, but I've got a large family, as you see. So my husband and I, between us, we have 6 kids. We're a blended family, but we've been together for 17. So we raised all those kids, and now they have spouses, and those are our grandkids. So I've always been passionate about like what would happen to my kids if something happened to me. Are they protected? Have I prepared sufficiently for them? So that kind of led me into estate planning, making sure my own minor kids were protected, and now they're all adults. And then you'll see on the right, so the other thing about me is the reason I got to know Carrie and Kelly is because of NothingPink. And that's because I did have the BRCA gene. And in 2018, I actually got diagnosed with lymphoma and went through chemo. And so you see me out there on the right without my hair. That's the day I got my hair shaved because I had a lot of chemo. And you see my backpack. I don't know if you can tell that I had a backpack with chemo in the back of it that I would wear around during my weeks of chemo. And I know you all maybe have been through chemo. I hear Kanae maybe got a loved one going through chemo right now. So fortunately, my lymphoma was cured. But I woke up about 2 weeks after knowing that I didn't have to have any more chemo and realized, oh my gosh, I have the BRCA gene. I do not want to go through chemo again. So that was a Saturday. Monday morning, first thing I call up my doctors who'd been advising me for like 5 years, even before I knew I had lymphoma, that I should be doing something about my BRCA gene. And I said, I am ready. Give me the double mastectomy, take out whatever you got to on the inside for the ovarian cancer risk. I am never doing chemo again. So a couple months later, I did go through and I had all the surgeries. That was the beginning of 2019, just all the preventative prophylactic surgeries because I did not want anything like that. And that is how I met NothingPink. Someone in a business networking group I went to, actually, I don't know even how they knew I was going to get the surgery. It's not something you generally advertise at a business networking thing. They were connected with your organization and they brought me over that wonderful care basket that NothingPink does. I think you still do. And it was the best robe I've ever had and all the things you would need for those surgeries. And so I've just been a super fan ever since and try to be involved with NothingPink whenever I can and give back because pay it forward, hopefully. So in the meantime, I got cancer, but I started my law firm right about actually the same year I got diagnosed with cancer. So it was a little slow start that first year, but the second year, 2019, we just took off running. And now we have a pretty large firm and we do things a little bit different. I used to think it was not a compliment when people said I was too nice to be a lawyer, but it actually works for estate planning because we're talking to people about things that are hard to talk about, end of life decisions and chronic illnesses and how do we plan and prepare for those things. So we like to say we really are like the Chick-fil-A of law firms. We really are nice. Everyone on my team, they don't work with us unless they're really kind and fun and nice. So that's what we attribute our success to. And there's myself. These are the other attorneys in my office. And so all we do is estate law. And so that's what we're talking about today is planning for incapacity and your passing. But even if you don't use us to help with your will, I just really want to strongly recommend that you go to a lawyer that only does estate law. It's a pretty specialized practice. And you see a lot of lawyers out there and they do like family law, but on Fridays they do wills. And we actually end up correcting a lot of those wills because there's just so much to learn in this area of the law. It would be like me practicing family law. I wouldn't be good at that because I don't do it every day. So pick someone that only does estate and elder law because they're going to be most current on all the laws. They're going to make sure your wills are correct and your powers of attorney documents are correct because it's really important that they're done right. Because when you go to use them, if they're done incorrectly, it's worse than well, not worse than not having anything at all, but it can cause some pretty big issues and delays. This seems like a question, but a lot of people ask, what is an estate plan? So it's getting those legal documents in place to plan for your inevitable passing or your incapacity. So creating wills, trusts, powers of attorney, living wills, those forms there. Another question we get a lot, just general, is what is probate? There's a lot of talk in the world like, oh, we don't want to go through probate when you die. That's the most horrible thing. So probate is the legal process after someone dies so that you can transfer assets into the person's name that they're supposed to be in. So whether, especially assets with the title, so cars, houses, bank accounts that didn't have beneficiaries listed, anything that needs to have the title changed has to go be reported to the probate court in the county where you were living. And the probate court charges fees on those things. Clerks have to often give permission for you to distribute those assets. So that's the probate nightmare. And we'll talk a little bit about that. I'm not going to go into these things, but this is kind of the probate process. When after someone passes away, in order before we can change the title on those assets, you go through this whole thing, and it usually takes about a year. So that's a whole nother topic. But when we talk about voiding probate, or you hear that word, this is what people are talking about. So today, I really wanted to talk about what if you didn't have a will or a trust and plan and something happened to you. And so the probate process is similar, but there's a lot more potential for conflicts and paperwork, etc., when you don't have a plan in place. So we're going to tell a little story today. And this is the Bliss family. And I made an assumption when preparing this that maybe people had children, whether they're minors or adults, but I'm going to talk about a situation for a family who they didn't have a will, they didn't have powers of attorney in place, and what happens to them. So this is your average American family. You got mom and dad. Mom was married before, and she had her son, Jake. And then together they had Ethan and Courtney, who are their kids together. So here's mom's ex-husband, Xavier. That's mom and Jake. And he's a good dad. They co-parent together, and he loved Jake. And they lived in a different house, and he paid child support. That's Xavier's house. And he actually had a life insurance policy that he set up for himself, and he named Jake, and I should mention that Jake is 10 years old, named Jake as the beneficiary of the life insurance policy. So that's a responsible thing to do. And remember, none of these people have an estate plan, so they don't have a will or anything. And there's sad days coming because Xavier turns 40. Not that that's sad. I actually loved my 40s. That's a great time of life. I'm actually in my 50s, and that's even better. So it's okay to age. But for his 40th birthday, he decided to go skydiving, and unfortunately, he had a terrible accident and didn't survive his skydiving. But remember, he did set up a life insurance policy for Jake. So Jake's going to be okay financially, his son. And it was $1 million, and Jake's the beneficiary. Jake's getting pretty excited about this because he's thinking, oh my gosh, I got all this money. I'm a millionaire. And of course, mom's not very happy about this because what kid knows how to spend money well. But the important thing to remember is that because Jake is under 18, he actually can't receive that money directly. So even though the life insurance policy said he gets the money, he's not going to get the money. So what happens? They go to probate court. And when they go to probate court, mom is going to assume she's going to be the one taking care of the money, but her uncle Mark shows up. And Mark is Xavier's brother, and he shows up and said, hey, Xavier's my brother. He would want me to take care of that money for my nephew. And I know it's maybe hard to vote on this, but any ideas? Maybe you put in the chat who you think the court's going to choose. Are they going to let Jake's mom take care of the money, or are they going to let Uncle Mark take care of the money? I know it's hard to be interactive. Any votes? Who thinks the mom? Maybe raise hands. Mark, because he's related. Mark. Yeah. So that's a trick question because the answer is unknown. It's up to the probate court judge. So if you haven't created a will or a trust to say who you want to take care of the money for your kids, the probate judge is going to decide. And we have good probate judges here in town, but they don't know everything. They don't know that Mark might be not good with money. Or maybe Mark isn't going to do the right things with the money, or he's going to spoil the child. So it's important that you memorialize your wishes in your will so that you get to choose who takes care of your kids. money. And I'm sorry, oh, there we go. Okay, so Xavier, he had, besides the life insurance policy, he also had a house and he had a car. And so, but he didn't have a will. And also Xavier had a new wife. So that gets complicated. So now who gets the assets? Is it the new wife? Is it his son, Jake? So if we're in general, since we're on the borders, I know some of you are in North Carolina, some of us are in South Carolina. In general, in both states, if you die and you don't have a will, your assets get split. If you have one child, it go 50% to the spouse and 50% to your kids, which might sound great and all, but remember, Jake is a minor. And so that's not ideal. I've laid out there's a few differences between the states. And in North Carolina, it's even a worse plan because if you have 2 kids and you live in North Carolina, the spouse gets 1/3 of the assets and the kids would get 2/3. And this can create a lot of problems, especially when the asset is like a house. And so this happens all the time where they own the house with their kids who are minors, and you can't sell your house even though you want to move. Maybe you can't afford that house anymore. You need to move after you've been widowed. You have to go to the probate court, have to have a hearing. The judge gets to decide that the house is sold. Then when the house is sold, let's say it's $200,000. Say the kids own $100,000 of the house and you own $100,000. The court makes you put that $100,000 into an account for your kids that they get access to when they're 18 years old. And you're only left with $100,000 to go buy a new house or something like that. So it can be a really tragic result, and also not to mention very costly because you're hiring lawyers to go to court to represent you. They hire lawyers to represent the kids. So sometimes we think, oh, I might not need an estate plan because, it's just me and my kids and I just have a house. But especially if your kids are under 18, super important that unless you want those kind of results, it's very important to name people in your will who are going to first of all, who gets your assets and who's going to take care of those assets after you pass away. Same result for the car. Kids would be half owners of the car, or in this case, Jake is. And we talk about going to a hearing for a judge to determine how that all shakes out. And I'm not going to go through all the details, but this is all the things that need to happen in that hearing in order for those assets to be distributed. So, and once Jake, who's a minor, gets those assets, they actually are going, just as I was talking about a minute ago, they're going to be required to be held in we call it a conservator account. And anytime, even though you're the mom and maybe you got control of those assets, because maybe the judge appointed the mom to be over those assets, every time mom wants to use the money to take care of Jake, she's going to have to, it's a form you have to file with the court. You don't have to go to a hearing, but there's a form you fill out. You say what you need the money for, and then the judge decides if you get money out of that account to spend on your child. And most likely when you've been widowed, you're going to need that money for your child. And so it's a lot of headache. And having a will where we create a little trust inside for minor children can resolve all these problems. There'd be no court involvement. You wouldn't have to be asking the court for money to pay for your children's needs because they're going to have a lot of needs. And the other risk of having minor children and not having a will is that if there's money to be had, whatever money is there, they're going to get all of the money. They'll have control of the money when they're 18 years old. So I don't know about you all, but I've got 6 kids, and even myself, I don't know, maybe like 1 out of my 6 kids would have been responsible with $1 million life insurance policy at 18. But I think the others, I don't know, they'd have some great sports cars, travel the world, and that money might be gone soon. So the other benefit of creating your own will and creating a trust is that you could name beneficiaries in that, you can name a trustee in that will, and you can name that trustee would take care of the money for Jake. And then you could say, I don't want Jake to have all the money or control of the money until he's 25, say, or 30, when he's a little bit older and we'd be more mature and make better use and better decisions with that money. So you would have control of when Jake himself got to have the money. There you go. Jake at 18, get in the car. So the best plan for our family to make sure, just after you lose the loved one, you've got all the grief and it's a hard time of life emotionally. And the last thing families want to be doing is even coming to an estate lawyer to figure out the estate, going to court, going to these hearings, feeling the stress of, who's going to be taking care of the money. Did I not get all the money because now it's in my kids' names, but I need the money to keep paying for my own bills. So the solution are to get a well-done will or a well-done trust to take care of those things and avoid going to the probate court. They've made all those decisions. So the takeaway is, if you don't make your decisions ahead of time by getting these documents in place, the probate judge is the one that gets to decide for you, and you don't want that to happen for your family. I think hopefully this addresses Rachel's question about, how does it work? What would next steps be? And so it would be similar with other firms, but with our firm, there's a questionnaire that you'd fill out, and we'd ask you, names of your family and loved ones, get some information from you. You come for a planning session, and at our firm, those consultations are free. So we just sit down, look at your assets, look at your family situation, just advise you on, what would happen to you if you didn't have a will. What would it look like if you had a will or a trust? How do we best take care of your family and your individual situation? And then a couple of weeks later, you have your documents drafted and you come and you sign them all. So it's about a 3 or 4 week process, and we can tailor that plan specific to your family. And I didn't talk much about powers of attorney, but I'll take a minute, and I don't have slides for that, but powers of attorney, I know they were alluded to when we were talking a minute ago. There's a healthcare power of attorney that's important and a financial power of attorney. So there are 2 different documents actually. And a healthcare power of attorney is where you name someone to make healthcare decisions for you. And we all know how important that would be in case you're incapacitated and can't make those decisions for yourself, that you've named who would make those decisions. And then there's also some options of outlining kind of what those decisions would be, especially for end-of-life care, life support, things like that. And then a document that people may not think is as important, and you don't hear about it as much, is that durable power of attorney. It's also known as a financial power of attorney, or sometimes people just use the word power of attorney. And if I have clients that come in and maybe they don't have very much money even, and they're saying, I need a will and a power of attorney, and maybe they can only afford one, I always tell them to get that financial power of attorney, because if that document, while you're alive, if you become incapacitated, you're giving someone else authority to take care of your bills and your finances. So if you haven't named someone to do that for you, your family, even your spouse, can't get to some of your accounts unless their name is on the account. So you might have money available to take care of you, but your family can't get to that money because they don't have access to your accounts. And that's what that financial power of attorney would give them. It's the authority to get into your accounts, pay your bills, make sure everything's taken care of for you that way. And the reason I say a power of attorney is the most important document we do maybe is because if you don't have that and your family needs to go access your money, then you're into one of those conservator hearings like we talked about a few slides ago. They have to go to the court. It's also called the guardian hearing in North Carolina. You're going to the court, you've got at least 3 attorneys involved, because you've got an attorney representing your family member, attorney representing you, and someone called the guardian ad litem representing the best interest of the individual. And so you're talking like a $10,000 hearing just because you didn't get that power of attorney in place. So I always recommend that. That's a super important document. And I know we talked about nobody likes to think about these things, and it's normal to think, oh, I'll do it one day. I'll put that off. We always have clients that feel guilty because they don't have a will in place and they're embarrassed about that. But please don't be. Everyone feels the same way. Everyone knows it's important, and we all think we'll get around to it. So anytime you want to do it, it's fine. And we don't want you to feel like you don't have to apologize to us that you don't have a will. But yeah, I think that's about it. If there's any questions.
Yes, thank you, Holly. That was wonderful. So I do have a question. Do you need to have a will in place in order to do the financial power of attorney, or that can be done separately
It can be done separately. Yes, they're different documents.
So if there's multiple steps, that would be one of the first you would recommend.
Yes, and often we take care of it all together, but certainly if finances are tight, it's like, well, we'll do it piecemeal, and we would generally do the power of attorney first before the will.
Okay. Well, it sounds like it would definitely be worth it, because in the long run, if you get in a situation like you were explaining, that would be much more expensive. So
Yeah, and stressful. Yeah,
exactly.
it's very stressful and time consuming. Yeah.
Yes. Well, and taking care of these things when we are not in an urgent situation is always best, I would assume. So thank you so much for your time and sharing this education with us, Holly. And we see SimpsonEstateLaw.com is how you can reach out to Simpson Law Firm. We appreciate you being with us today on Carolina Breast Friends YouTube channel. Thank you so much.
Yeah, thank you for having me. That was fun.